on the origination clause says that revenue measures have to start in the House of Representatives, not in the Senate. Back to the time when the House was directly elected by the people and the Senate was elected by the state legislatures. Obamacare started in the House to the extent, which is pretty tiny, that the Supreme Court cares about enforcing the origination clause judicially. The House passed a bill on something that Veterans Affairs or something. It had nothing to do with health care. The bill goes over to the Senate. Harry Reid, when it's over in the Senate, strips the entire language of that House bill out below the enacting clause and substitutes in the Senate version of Obamacare. The Senate passes that. It goes back to the House. The House concurs on Easter Saturday. And so the bill, in a nominal sense, did start in the House, and that's as much as, in terms of lawsuits, that it's immune under origination clause challenge. Let me tell you about quickly two things that are coming up. One is there is a First Amendment challenge, which I think is, you can never say it's a guaranteed winner, but is at least a strong case about the Kathleen Sebelius mandate that religious institutions like Catholic hospitals have to provide abortion pill insurance paid for their employees. There's that issue. That's a First Amendment issue, and more particularly involves the Religious Freedom Restoration Act, a law enacted by Congress, which is, by its terms, applies to everything any future Congress does, unless the future Congress explicitly writes it an exemption. And then the second thing is the death panel. And contrary to what you might have heard, there will not be actual death panels like in some science fiction thing where you'll have 5 people sitting around deciding who in particular one at a time gets health care or dies. Rather, we have a much more efficient, collectivized death panel called IPAB, the Independent Payments Advisory Board, which is to set standards for what kind of people in general get what kind of treatment. There are profound constitutional problems with that, about this Congress, the enacting Congress's ability in 2010 to prohibit other Congresses from doing anything, such as prohibiting them, supposedly, from repealing IPAB. And likewise, the Independent Payments Advisory Board, a agency, a unit within the executive branch, is given the power to appropriate money to itself. It says, hey, we need $300 million more dollars. Well, okay, give it to us. That's not how the Constitution works. The only body that can appropriate money is the Congress of the United States. Now, certainly, the 2010 Congress could have said, oh, here's $11 trillion, here's $500 billion, and we bury it in the backyard behind Congress, and whenever IPAB wants it, they can have some. That's fine, because that's been appropriated. But under this, the way it was enacted, IPAB just gets to say, we need more money. And they get it automatically out of the U.S. Treasury. A flagrant violation of the Constitution. And there are other similar structural problems with the IPAB death panel. So we got the death panel and the abortion pills, so that's 2 cases that will be going on, and it wouldn't surprise me if there were more to come after that.